Hello, my name's David Thomas. I'm one of the barristers at 2 Temple Gardens and a co-author of the Defective Premises Act 1972 chapter in Chambers' upcoming book in respect of property damage. I'd like to talk to you today a little bit about the 1972 Act, and in particular, why it is such a powerful tool in the hands of those who may want to bring claims in respect of defective premises. As a statute, the Defective Premises Act 1972 has had an unusual life. Often statutes are enacted to a blaze of publicity and early application by the courts, so that their meaning is relatively quickly understood. However, this was not really the case for the Defective Premises Act. It was introduced as a product of the Law Commission's 40th report on the civil liability of vendors and lessors for defective premises of 1970, and which criticised the continued application then of the common law doctrine of caveat emptor, buyer beware, to the purchase of new or nearly new residential properties. And when initially enacted, it imposed a statutory duty on those involved with the provision of residential property to ensure that the property is fit for human habitation when completed. As such, it was intended as a statutory safety net for the recent purchasers of newly built residential properties. The Act had a slow start during both the 1970s and 1980s, and two factors contributed to this. First of all, until April 1979, all homes constructed under what was then the NHBC's Build Mark scheme were excluded from the application of the Act. The vast majority of homes were built pursuant to that scheme, and so therefore the Act was not of wide application in those early years. Secondly, once after 1979, the NHB Build Mark scheme was no longer excluded from the Act, but there was a potential cause of action in the tort of negligence following the decision of the House of Lords in Annes and Merton London Borough Council of 1977, in which it was held that a builder may owe a duty in respect of negligent defective property, even where that had not caused damage to other property or personal injury. The decision in Annes was overruled by the House of Lords in 1990 in their decision in Murphy and Brentwood District Council, in which it was held that defects of quality within a property which were discovered before they had caused damage to other property or personal injury was pure economic loss, such that no duty of care would normally be owed in the absence of a specific assumption of responsibility. As such, it was only since the early 1990s that the cause of action in negligence was authoritatively taken away by the House of Lords, such that the real impact of the Defective Premises Act 1972 has only been felt since the 1990s, and the preponderance of authorities upon the Act come from that time frame. The Defective Premises Act has then had something of a rebirth with the enactment of the Building Safety Act 2022, which is a wide-ranging statute intended to address issues arising out of the Grenfell Tower tragedy, and which includes amendments to the Defective Premises Act. In fact, the Building Safety Act has introduced the most significant amendments to the Defective Premises Act since its enactment. It should be remembered that the amendments, which we'll come on to discuss, to the Defective Premises Act, as provided by the Building Safety Act, are not limited to cladding claims or fire safety claims, even though the context was the Grenfell Tower tragedy. But they will apply to defective workmanship or materials in the provision of a dwelling, making it unfit for habitation, no matter what the cause of that unfitness is. In particular, sections 127 and 128 of the 2022 Act, which came into force on the 28th of June 2022, amend the Defective Premises Act by, firstly, imposing a new duty under section 2A of the DPA, which extends liability under the DPA to include works carried out on existing dwellings, and also in respect of mixed-use developments, where at least one of the uses is as a dwelling. It also, and as will be well known, extends the limitation period under the Defective Premises Act in a powerful and partially retrospective way. So for the purposes of this talk, rather than simply going through the limbs of the Defective Premises Act, what I really want to consider is how powerful the remedies under the Defective Premises Act 1972 now are. And there are several elements of the statute as amended that make it so. Firstly, the scope of its application, given the new section 2A. Secondly, the breadth of potential defendants to a claim under section 1 or section 2A DPA. Thirdly, the breadth of potential claimants and the fact that under section 1 and section 2A, there is a transferable warranty in effect, in the sense that the cause of action may be transferred from one person to another who acquires an interest in the property. Fourthly, the threshold test of fitness for habitation, and whether it is that high as a matter of practice, despite the wording which does suggest a relatively high test. And fifthly, the generous limitation provisions following the coming into force of the Building Safety Act 2022 in June of this year. Going first of all to the scope of application. Section 1 of the Defective Premises Act applies to the provision of a dwelling, and that is whether the dwelling is provided by the erection or the conversion or enlargement of the building. The paradigm here is a developer or a builder building a house on an estate, but following Rendlesham and Barr, it's also been interpreted to apply to a block of flats, which comes as no particular surprise. The new section 2A of the Defective Premises Act extends the duty, however, to work in relation to any part of a relevant building, where relevant building means a building consisting of or containing one or more dwellings. Thus, the duty in section 2A will apply to work to existing dwellings, work to a building which contains one or more dwellings. For example, it could apply to work to an industrial or commercial building with, say, a caretaker's flat, or a supermarket with a block of flats above it. And it also applies to work to any part of that relevant building, and not just work to the dwelling in the buildings. So therefore, for example, if cladding were to be applied to the industrial part of a building, the effect on fire safety to the dwelling as contained with that building may still cause section 2A to be triggered. It should be noted that the proposed section 2A only applies in relation to work completed after the coming into force of that section. So it's not retrospective and applies only to works completed on or after the 28th of June 2022. But going forward, this means that an awful lot of construction, building, renovation work is potentially caught by the Defective Premises Act. The second issue I want to consider is who can be sued under the Defective Premises Act, sections 1 and section 2A. The duty owed under section 1 Defective Premises Act is owed by any person taking on work for or in connection with the provision of a dwelling. And that scope of duty is reflected in section 2A, where the duty is owed where a person in the course of a business takes on work in relation to any part of the relevant building. Now, this has always been intended to be a broad definition, and the Law Commission, in its report of 1970, considered that it should not only apply to the builders doing the works themselves, but any building subcontractor, or indeed any other professional, including architects, etc. In the early case of Alexander and Macoris, Lord Justice Buckley commented that this expression meant that the duty was not only owed by those under a contractual obligation to do the work, i.e. the main contractor and contractors going down the contractual chain, but also by persons who may have been owed a quantum merit for the work, those who did work for free, and indeed by building owners who did works themselves. So broad is the definition of those who take on work in respect of a building, is that a question remains as to whether those who merely supply materials for the use in the construction of a dwelling, or in the performance of work in relation to a relevant building, will owe a duty under the Defective Premises Act. The Law Commission in their 1970 report considered that a distinction should be drawn between those who supply purpose-built components and those who supply mass-produced components or general building components. Mr. Justice Latham, in the case of Mirza and Bandal, considered that the provision of materials may not constitute work within the meaning of the Defective Premises Act, which would seem to exclude even the provision of purpose-made materials from the Act. However, there is probably a debate to be had here, especially considering modern construction techniques for both individual dwellings and for tower blocks using modular construction and prefabricated components, including, in certain cases, particular pods of bathrooms and kitchens, and whether it would be said that they have taken on work within the meaning of the Act. The primary definition of those who take on work is also extended in both Section 1 and Section 2A as follows. Under Section 1, Section 1(4)(a) provides that a person who, in the course of a business which consists of or includes providing or arranging for the provision of dwellings or installations in dwellings, arranges for another to take on work for or in connection with the provision of a dwelling, shall be treated for the purposes of this section as included among the persons who have taken on that work. And there is a similar extension within Section 2A, subsection 7, in respect of the Section 2A duty. The effect of these provisions in very general terms is to impose a duty on what may be thought of as developers, as opposed to those builders or architects actually performing the design or construction work. The Law Commission's rationale back in 1970 for including this extension to those who take on work was twofold. Firstly, those who purchase a new home do not normally consider the distinction between, say, the developer who sells them the home, the Barretts, the Redrows of this world, and the builder, the building company, the contractor who might have actually built that house or block of flats. And secondly, without this extension, there is the risk of evasion in that the entity that was the true commercial driving force behind the development could avoid the effect of the Defective Premises Act by contracting out all the work through a single purpose entity with no assets to satisfy any liabilities that may ultimately arise. However, whether or not a person is acting within the course of a business so as to fall within the developer extension is a difficult question of fact, especially given the more modern tendency of individuals who wish to build their own dream homes or who wish to build their own homes to sell on in order to move up the property ladder, reminiscent of television programs like Grand Designs. In the TCC case of Zenstrom and Fago, a case that two of the authors of this chapter within the book appeared in, there was certain discussion of this and the difficulty of drawing a distinction between those who develop a property with the intention to sell the property as soon as possible after they've completed it for a profit, and not to live in the property for more than a minimal period, on the one hand, who would be seen as developers, and those, say, who wish to build their dream home or who wish to live in a property for a certain period of time before selling it in order to make even some capital gains as they make their way up the property ladder, on the other hand. The third element of the strength of the Defective Premises Act is that a wide number of people may sue under Section 1 and Section 2A of the Defective Premises Act, certainly wider than standard liability scope of who can sue in either tort or in contract. Provided that a duty is owed under Section 1 or Section 2A of the Defective Premises Act, the duty will potentially be owed to two sets of people. Firstly, a duty would be owed to the person to the order for whom the work is done. Secondly, and perhaps most importantly, pursuant to both Section 1 and Section 2A, a duty will also be owed to each person who holds or requires an interest, whether legal or equitable, in the dwelling within the building. As such, this creates a transmissible warranty of quality in those works in the favour normally of subsequent purchasers. And as we'll come to see in respect to the limitation periods, there could be quite a number of subsequent purchasers who may have a right to sue under the Defective Premises Act, even though any tortious liability would not be owed and there would be no chain of contracts between them. Fourthly, perhaps the biggest limiting factor within the Defective Premises Act, under both Section 1 and Section 2A, is that for there to be liability, it must be that the dwelling is rendered unfit for habitation. At first glance, that may seem like quite a high test. However, the concept is not as straightforward as it may first appear, and the case law in this area has demonstrated that it's not limited to hovels or slum dwellings, but the concept must keep pace with modern standards and expectations. And particularly in the period post-Grenfell, one can see that even a luxury flat with all the amenities, but with a potentially combustible external rain screen cladding, may still be considered unfit for habitation if the risk of a fire causing injury is unacceptably high. Perhaps the best guidance was given in the case of Bowl and Huntsfield at first instance by His Honour Judge Toulmin QC, who said at paragraph 38 of his judgment that the finding of unfitness for habitation is a matter of fact. It extends to both defects of quality, rendering a dwelling unsuitable, as well as dangerous defects. A distinction should be drawn between those defects, whether they are defects of quality or defects of safety, which render the dwelling unsuitable for its purpose, and those which are mainly minor defects. And a defect in one part of a dwelling may render a dwelling unsuitable for its purpose, even if the defect does not apply to other parts of the dwelling or the building. For example, it may well be that a particular flat within a block does not have combustible cladding on its outside, but it is 18 stories above a structure which does have combustible rain screen cladding system, and it may still be thought that the dwelling in question is unfit for habitation. The Act will also apply to latent defects, and when considering whether a dwelling is unfit for habitation, one must consider the effect of the defects as a whole. As such, this is a very fact-specific test, and given that modern expectations of standards, either for new builds or for buildings which may not be new builds, but work has recently been performed upon them, such that a duty is owed under Section 2A, the test of unfitness for habitation may be surprisingly high. Finally, and recently, the Defective Premises Act and the remedies under it have been significantly strengthened by changes in the limitation provisions. Prior to Section 135 of the Building Safety Act 2022 coming into force on the 28th of June this year, the limitation period for claims under Section 1 of the Defective Premises Act 1972, which at that point was the only relevant section providing a remedy, was 6 years from when the work was completed. However, under Section 135 of the 2022 Act, a new Section 4B has been added to the Limitation Act 1980, which extends the limitation periods under Section 1 and Section 2A for 15 years prospectively for claims which accrue after the Building Safety Act 2022 took effect. Moreover, Section 135 also retrospectively extends the limitation period for claims under Section 1 of the 1972 Act for 30 years. So this means that claims in respect of breaches of Section 1, which accrue before the Building Safety Act took effect, have a limitation period now of 30 years, where previously there was a limitation period of only 6 years. This is a very dramatic change to the limitation period, and in particular, the retrospective effect of changes to that limitation period is something quite unusual under English law. As such, where a claim is made using the retrospective effect of the limitation period, the Building Safety Act 2022 includes 2 safeguards which are intended to ensure fairness. Firstly, a claim must be dismissed if the retrospective limitation period breaches a defendant's human rights. Now, what this means in practice is unknown. It is thought that potentially one way that a defendant may mount a defence relying on this subsection is if it means that the retrospective effect of the limitation period is that the defendant's document management policies mean that it destroyed documents that may potentially have provided it with a defence, thinking that it was facing limitation periods of 6 years and or in respect of latent defects, where in fact it is now obliged to consider claims reaching all the way back to the early mid-1990s. A further safeguard is that a claim which has previously been settled or finally determined by a court or arbitration cannot be resurrected simply because of the extended limitation period. And that would be the case even if that settlement or determination arose because of the previously shorter limitation period. The Building Safety Act also recognises that some potential claimants may find themselves perilously close to the end of the 30-year retrospective limitation period. And for those claimants, it provides that the limitation period for such claims will not expire until 1 year after the new limitation period came into force. So there is a 1-year buffer for claims where the 30-year limitation period may have been coming to its end shortly. These amendments to the limitation period are likely to give rise to much litigation as to how they are to be applied in practice, but they show the centrality of the Defective Premises Act 1972 when it comes to establishing liability for defects in buildings that may have been built quite some time ago and where the contractual and tortious limitation periods have long since expired.